Please join me in welcoming the Honorable Greg Abbott. General, thank you again for being here.
Thank you, Evans.
Very nice to see you, sir.
You too, thank you.
Did you watch the debate?
I did.
Yeah.
I thought it was fantastic.
It was a very interesting debate. I promised not to look down and seem unhappy to be here if you promised not to weirdly tack to the center. How about that?
Yeah, well, that's a guarantee.
Okay, good. Yeah, I wasn't worried about either of those things actually happening.
My favorite line of the debate, though,
Yeah.
was when Mitt Romney was talking about the failure of Solyndra and many of the other ways in which Barack Obama has decided to invest your taxpayer dollars.
Right.
And Mitt Romney said that it looks like the president doesn't pick between winners and losers, he just picks losers.
Zing. Right. One of those many zingers that we were promised. General, let me begin by getting right to the substance of our conversation. Let me begin by asking you about a column that my colleague Ross Ramsey, who is right over there, so when I read this to you, you look at him and answer him directly.
He's not even paying attention.
Oh,
he's typing over there.
He's either, I think he's tweeting it actually. Ross wrote a column about a month ago following the court decisions on voter ID and redistricting, in which he talked about what he described as your losing streak. You had spent a lot of time over the last number of years suing the federal government. I believe, according to the AP's story recently, 24 federal lawsuits, $2.8 million spent, more than 14,000 man-hours of employee time in your office on these suits. And referring specifically to the voter ID and the redistricting decisions, he said, it would be fair to say that General Abbott is getting the stuffing knocked out of him on issues that matter to Republican voters. Was Ross right? Are you getting the stuffing knocked out of you?
Can I see that? Because here's the deal. Even Ross says in here, looking for the paragraph, but right before that he says, well, Abbott just had two big victories against the EPA.
True.
In the Court of Appeals. And then he says, well, Abbott's on a losing streak.
Well, I think the totality of your record, I think he was saying, yes, he won against the EPA, but he lost on voter ID, he lost on redistricting, he even lost, along with the other state attorneys general, on health care.
Well, let me answer those three.
Yes.
Because if you recall, when the first redistricting decision was issued out of San Antonio, we lost. Everyone said, oh gosh, it was awful, we did such a bad job, et cetera, et cetera. It took us a few weeks to prepare the appeal to the United States Supreme Court. It took a few weeks for the United States Supreme Court to decide to take the case, and then it took a few weeks for the Supreme Court to issue an opinion after an oral argument. And we got something that is very rare. We got Chief Justice Roberts, Scalia, Alito, to agree with people like Kagan and Sotomayor. We got a unanimous decision out of the United States Supreme Court saying what the lower court did in the first round of redistricting was completely wrong. And so despite the fact that we had one lower court decision that was erroneous on redistricting, we got a unanimous Supreme Court decision to quickly overturn it. Everyone acts like, well, gosh, this new redistricting decision shows that we've lost, completely forgetting that just a few months earlier this year, we've been back up to the U.S. Supreme Court and we won. So here's the deal. This is a way station.
Yeah.
We believe once again, when this case gets up to the United States Supreme Court, which we're on the pathway to get there now, once again, we're going to have a United States Supreme Court overturn a lower court panel's ruling on redistricting. What this lower court did is antagonistic to prior Supreme Court dictates and precedents on the redistricting law. What this court did in redistricting in Washington, D.C. was, for the first time, under Section 5, require that coalition districts must be created by state legislatures, that crossover districts must be created by state legislators that are subject to the Voting Rights Act, and that districts must be created for proportional districts for new adjustments in population. The United States Supreme Court has never required those three things under the Voting Rights Act in the past. We believe because of those new three mandates that were imposed by this three-judge panel in Washington, D.C., we will be just as equally successful in our appeal of the redistricting case. But second, there was something else, if we could, if you want to look at the fine print in there that Ross wrote about. If I could take issue with Ross, because for one, Ross and I have known each other a long time. And I consider Ross to be probably at the very top of the game journalistically. Every time except this time, Ross will talk to us before he writes a piece. This time he didn't talk to us, and therefore I think he got caught up in the echo chamber of what happens in Austin, Texas, when he criticized us in that piece, saying that, well, we made a strategic error in the whole redistricting lawsuit because we went to this 3-judge panel as opposed to first seeking pre-clearance from the United States Department of Justice. And he did that without thinking through the mathematical equation of what would happen had we sought Department of Justice pre-clearance for redistricting. Everyone acts like, well, gosh, had we just sought DOJ pre-clearance, we would have heard back from them, everything would have been fine, and we would have gone about our lives. It's not true. Ask yourself the question. You, in your own mind, have to ask the question, what would have happened had we sought DOJ pre-clearance for redistricting? Alan Blakemore, as usual, is first with the answer and got it right. And it was the anti-Aggie, it was the thumbs down sign, which means that we would have lost. We have the benefit of hindsight now. In hindsight, we know that the United States Department of Justice was not going to pre-clear the redistricting maps passed by the state legislature. They were going to reject them.
Because
the DOJ disagreed with the state legislature's plan and would have concluded that there was retrogression, therefore they should not have been approved. And we saw precisely that in their arguments. But here's
you think it was politics as opposed to law that would have driven that decision?
Well, I do, and let me answer that question. Let me finish this though.
Yeah.
Because this is the important point. When we would have lost the DOJ pre-clearance, what would have happened next? Would we have just come back and say, okay, state legislators, you have to live by that decision? The answer is no. We would then have appealed the DOJ denial of pre-clearance to the very same court that we appealed to begin with. The difference is we would have been months behind where we turned out that we were.
So you eliminated a step.
We eliminated a step. So by not seeking DOJ pre-clearance that we knew we were going to lose on, and by going ahead and filing the legal action in court, we were able to get months ahead down the road than where we would have been had we not sought DOJ pre-clearance.
But General, at the end of the day, what the court found, and I'm again quoting Ross's language, but I believe the facts of this are not a dispute. You may have some issue with the process that got us here, is that in the end, the court found that the Republican legislature did not protect minority voters adequately as the law requires. You take issue, leaving aside what preceded it, you take issue with that specific court finding.
I do want to say, I'm taking a sip here, and I realize I have water, and you have water, but you have a secret cup.
If you had texted
here.
me your order, I would have gotten you something from Starbucks.
What the court found in the redistricting process was completely wrong for several reasons. One, as I mentioned already, the court created 3 new standards. Had the court not created those 3 new standards, the court could not have been as extreme, and the decision would have been much more in line with what the legislature passed. The court did something else, however, that was even more disturbing. If you read the court's opinion, you will find that what the court has now done is to equate minority voters and Democrats. It says as much in its opinion that if you're a minority, is a Democrat. And therefore, when you look at how lines are drawn, you look if the line is drawn in a way that elects a Democrat, then that must be a district that protects minorities. However, if lines are drawn in a way that protects a Republican, then it could not be reflective of what the choice was of minority voters. And here's the most offensive thing about it. And that is, if you go back and look at a lot of the lines in districts that were rejected by the court, many, if not most of them, were lines that were drawn that protected Hispanic Republicans. So this court had an agenda.
You think it was a political agenda?
Oh, it was completely, unequivocally a political agenda.
And General, so you've spent, again, the AP story says you've spent about $900,000 so far on this case. Your intention is to go forward and press this thing to the end.
Well, first, the answer is yes.
Yeah.
However, let me answer the cost equation also.
Right.
And that is about half of the money
Yeah.
that we have spent on this case so far was the money that we spent going to the United States Supreme Court the first time, getting the erroneous lower court decision overturned. Had the lower court in San Antonio not issued an erroneous decision, had the lawyers making the arguments to that court not pressed the court to make an erroneous decision, had those very same lawyers not made erroneous arguments before the United States Supreme Court, we could have saved half of that money.
You can't collect that money under loser pay? Didn't you just pass loser? I guess not. General, so
That
you're
would be
going to...
reverse preemption. We do believe Texas law should be preemptive of the United States law.
So you're gonna. I've heard that actually from you and from the governor specifically. So you've done that much on redistricting. Let me move over to voter ID. You know what happened in Pennsylvania this week? A Pennsylvania judge stayed the Pennsylvania voter ID law. Voter ID laws around the country have gotten a lot of attention. People who don't like them call them voter suppression laws. People who do like them call them voter security laws. Semantics is everything in politics. But at the end of the day, the voter ID legislation that has gone from state to state to state around the country has been really under assault. In Texas specifically, again, what Ross said in his story was that the voter ID law unfairly burdens minority voters. That was the most recent finding of the court. And it had to do with both the cost of the IDs that would be required for people to procure, but also the distance between DPS offices that would be the locus that people would have to go to get these IDs. One statistic I've heard is that 81 of the 254 counties in Texas have no DPS offices. In another 30 counties, they're only open like 2 days a week in very limited hours. This is specifically from the ruling, from the decision. While a 200 to 250 mile trip to and from a DPS office would be a heavy burden for any prospective voter, such a journey would be especially daunting for the working poor. And here's a case where the court is equating the working poor with minority voters. Therefore, this disproportionately affects them. And so that's why they say this voter ID law is bad for minority voters. Tell me how they're wrong.
How many of those working poor minorities don't have a driver's license or a valid ID?
I'm assuming you know the number because I certainly do not.
No, the truth is, I don't know the number, the court doesn't know the number, you don't know the number, no one knows that number. So this is a logical equation that is missing a key fact in support of the equation. But let me go back and answer all your questions.
Yeah.
Let me answer the big question that you raised first. You brought this up by talking about Pennsylvania,
right,
and by other states. If you've been following voter ID, you've seen that there are legal challenges involving voter identification laws in states around the country. So what's going on here? Is this some massive effort to try to achieve some kind of voter suppression across the country? The answer is no. There is a reason why voter ID laws have been springing up over just the last few years. The reason for that is because it was just 2008 when the United States Supreme Court issued its decision in the Indiana case called Crawford that said that voter IDs were perfectly constitutional. Important fact also is that in that decision, which occurred, if you recall, the same year that Barack Obama got elected president, at that time, the United States Department of Justice filed a brief in support of voter ID. United States Department of Justice said that voter IDs were extremely important in trying to crack down on voter fraud. In fact, voter ID is pretty much the only way that you can prevent voter impersonation at the polls. So, in the aftermath of that Supreme Court decision, you've seen other states realize, well, this is a valid constitutional legal tool that we can use to try to address voting irregularities, voter fraud that occur in our various states. Extremely important point that came out of that Supreme Court decision. You know, a lot of people, and you probably may argue this also, and that is exactly how many instances of voter fraud have occurred in the state of Texas or anywhere.
Well, this is the argument that you have a solution in search of a problem.
Right. That could have been prevented. Here's the important point. both the United States Supreme Court and the Washington court that ruled in our voter ID case answered that very question. Both said the law requires proof of 0 instances of voter fraud that could have been prevented by a voter ID.
So even one is too many? Is that the point?
Well, even one is sufficient proof,
Yeah.
but even none is sufficient proof because of the concern about voter integrity and voter fraud. That alone is enough to allow the states to impose voter ID. But let me go back and answer, because you raised another question that I would like to try to answer. And that is this issue about voter suppression. 2 key points about it. One is people like to say, well, there's voter suppression. There's no proof. There was no proof at this trial that there would be voter suppression. You mentioned these people who were impoverished, who may not be able to get an ID, who may have to travel a long way. There was no proof at trial of identifying anyone who was so poor they couldn't go get an ID. Putting aside the fact that the United States Supreme Court itself, in its opinion, said, listen, these photo IDs are so prevalent in our society today, it is not asking too much for people to show an ID when they go vote. Point 1. Point 2, what is wrong with requiring that you prove who you are when you go vote? But here's the third point, Evan, that's incredibly important. As opposed to hypothesizing about whether or not there's going to be voter suppression, let's look at real life examples. There are several states that have had voter ID laws in place for several election cycles now. One is Indiana and the other is Georgia. In both of those states, voter participation by minorities has increased, not decreased, after the imposition of the voter ID law.
But General, but I'm glad you brought up Georgia. Georgia's a very good example. Another state subject to preclearance. In Georgia, part of the voter ID legislation is that every county has to have an office to which people can go and get an ID. And they also permit a much more lenient process to acquire these IDs. The proof to get an ID in Georgia is much more significant. A question of your office and a question of the legislators who supported this bill has been, if you're not interested in suppressing the vote, then why not go out of your way to make it as easy as possible to allow people to get IDs and make the cost as low as possible and make the proof to acquire an ID as lenient as possible? Why not do what Georgia has done if Georgia is the model?
Well, let's talk cost and distance,
Yeah.
which were 2 issues the court raised.
Right.
So you say you have to, for some people who live in these 81 counties, which we know those 81 counties are not Travis County or Harris
No,
County.
it's Loving County.
Loving
Yeah,
County.
right, yeah.
So in Loving County, you may have to go, let's just say, for our discussion purposes, 100 miles in order to get an ID. Tell me, Evan, how far will someone have to go to cast a vote in Loving County?
I assume they're going to the courthouse, right? I mean,
How far is that?
I have no earthly idea.
Here's the point. In those counties where people have to travel a long distance in order to get an ID, these people have to travel a long distance to do anything. If you want to go grocery shopping, if you want to go pay a traffic ticket, if you want to go register to vote, if you want to go cast your vote.
Is that really a rebuttal, General, of the
Sure.
suggestion that it's onerous? Is that really a rebuttal of the court's point?
Well, if the issue is whether or not it's onerous, it's an issue that is in our favor because the United States Supreme Court has answered this question. And they say that having to take time out of your daily routine, which includes going to work, having to gather all your documents, having to travel down to the Department of Motor Vehicles to pose for a picture is not an infringement on your right to vote. And people can travel short distances in Austin, Texas to go vote, to get an ID. People in Loving County travel long distances to do everything.
Yeah.
They're not going to have a corner store they walk down to from their house in order to either cast a vote
Right.
or to get a voter ID. But let me answer the cost question
Yes.
also.
Do you consider $22 for an ID to be, as the court apparently does, too much of an imposition on the working poor?
Okay, here's the point. The United States Supreme Court upheld a similar law in Indiana, where in Indiana, the costs range up to $12 a person to get a voter ID. The court added a footnote to that, saying that in some other states, it costs more. Let me clarify what I said. They said it costs, what I just said is it costs up to $12 to get an ID. There are different ways of getting an ID, one of which is by getting your birth certificate. It costs up to $12 in Indiana to get a copy of your birth certificate so you can get your ID. In Texas, it costs up to $22 to get a copy of your birth certificate to get an ID. But the court added a footnote saying that in some other states it costs more than it does in Indiana. So these are the two takeaways. One is the United States Supreme Court recognizes that it is going to cost something in order for you to have the documentation in order to get a photo ID. The cost in Texas is $10 more than it was in Indiana. A $10 difference, in my opinion, is not a constitutional difference. But even more so, because the court flagged the point that in some other states it costs more than $12, that means that even by the United States Supreme Court own standard, the upper boundary is going to be somewhere higher than $12.
Let me quickly, we have about 10 minutes left and I want to get to some other things, but let me quickly ask you about the question of evidence of voter fraud, because this is one of the things you often hear. The opponents of the voter ID bill will often say, but you haven't proven the case. You wrote an op-ed in USA Today and Mayor Everyone Elsewhere in March in which you said that you cited 50 instances over the last few years of voter fraud. Doesn't seem like very many to me. I looked then at this study that you even know about the so-called News 21 study that the Carnegie Corporation and the Knight Foundation commissioned, in which they analyzed 2,068 cases of alleged election fraud since 2000. Of the 2,068 cases of alleged election fraud, a total of 10, not 10%, 10 were found to be voter impersonation, 0.5% of the total, versus almost 24% of the total, 491 of those cases, were absentee ballot fraud. There seems to be some acknowledgement that the real problem on voter fraud is not voter impersonation, but it's mail ballot fraud, and voter ID has nothing to do with mail ballot fraud. If you truly want to solve the problem of voter fraud, why not run to the place where it seems to happen most frequently as opposed to a small fraction of the cases?
Several key points.
Yeah.
First and most importantly, and that is to reemphasize what I said earlier, and that is in order to have a voter ID law upheld as constitutional, we don't have to prove any instances of voter fraud that could have been prevented by voter impersonation. That is the ruling by the United States Supreme Court. That, Evan, is the ruling by the federal pre-clearance court that ruled against us in voter ID. That court agreed we don't have to prove any instances of voter fraud that could have been prevented by a voter ID. So it's an interesting intellectual issue.
Well, do you dispute that the evidence is scant?
I'm going to answer that, but I want to make sure we're all on the same page.
Yeah.
It is nothing more than an intellectual issue. It's not a legal issue. But intellectually, there are some other very important points. Point number one is, by you bringing this up about the voter fraud prosecutions I've waged, you act as though I'm the only authority in the state of Texas who either investigates or prosecutes the voter fraud. If you look at what a DA in South Texas did last week, he's hiring more investigators to crack down on voter fraud that's taken place in South Texas. If you look at what the United States Department of Justice has done, they've cracked down on voter fraud. All the DAs, all the county attorneys across the entire state of Texas, which means there's more than 200 of them, have the ability to crack down on voter fraud, and I have no idea how many cases they've been involved in that regard. Okay. And so voter fraud remains a serious problem, but let's look at this. Let me give you one example. Let's say that there's only been one example of voter fraud ever in the history of this country post-LBJ.
Well, that wasn't very sporting of you.
You can see how one example of voter fraud can change the future course of this country. And it comes in the two words of Al Franken. Remember this, Al Franken won the United States Senate by 312 votes. It's widely agreed upon right now that there were more than 1,000 fraudulent votes cast in that race. Those more than 1,000 fraudulent votes were cast by felons who didn't have the right to cast a vote. Now, I don't know for sure, but I have a hunch those felons did not vote for Al Franken's Republican opponent. If those fraudulent votes had not
Well,
been
Norm Coleman was not as funny as Al Franken during that campaign. That's probably why.
if those fraudulent votes had not been cast
Yeah.
and Al Franken had not been elected, there would have been one less vote in the Senate for Obamacare, and Obamacare would not exist today.
And if Clayton Williams had shaken Ann Richards' hand back in 1990, George Bush never would have been president. I mean, this seems like an unnecessary exercise.
No, people say voter fraud doesn't have any consequence. We know that voter fraud elected LBJ to the United States Senate.
No.
It's fair to conclude that voter
No,
fraud...
in air quotes. We know.
Yeah.
We don't actually know it. We know it.
I know, but it happens every day that people sign into the ballot box in alphabetical order, all in the same handwriting. But just enough number to win an election. We also know that Al Franken was the beneficiary of voter fraud, and we know that there's a real consequence that affects the daily lives of all Americans because of both of those.
So if one instance of voter fraud is too many, would you make the same argument on the death penalty, that one innocent person being executed is too many and we should have a moratorium on the death penalty?
I believe that one innocent person who is put to death under the death penalty absolutely is too much. However, you can't ipso facto conclude, well, we need to have a moratorium on that. That would be like saying if one instance of voter fraud is too many, we need to have a moratorium on elections, and so we don't have any more elections until we know we won't have any more cheating in the ballot box.
All right.
But we in Texas believe in the death penalty. We know that one thing that would erode the ability to have the death penalty instead of Texas would be if an innocent person is put to death. We need to make sure we have the systems and procedures in place to ensure that no innocent person is ever executed.
Okay, we've done a lot of substance and it's been real fun, and I've been a good boy, General. We talked about policy. Now I got to get into the kabuki theater of politics, because that's what everybody here came to hear. Are you running for governor? I can't believe I didn't ask that question first. I was really restrained, General, I have to tell you. Are you running for governor in 2014?
As you know, I have announced what, if anything, I'm running for in 2014. It's very important to understand that it was less than 2 years ago that the people of Texas elected me to be their Attorney General. They expect me to be their Attorney General to bring these actions from an overreaching federal government to protect them in their daily lives. And as you know, because of what we've been talking about, that's exactly what I've been doing.
Yeah.
I'm going to let politics take care of itself.
What does that mean exactly?
That means that I'm not announcing for governor, lieutenant governor, attorney general, dog catcher. That what I'm announcing is that I'm going to go to work every day, work hard to do the best job I can as the people's attorney general.
And at an appropriate point, which might be, for instance, June 2nd of next year, you will then tell us what you intend to do.
I will let politics take care of itself and address it when re-election time comes up.
May I ask, I know you're not going to tell me, but let me ask anyway. If Governor Perry decides to run again, would you challenge Governor Perry in a primary, or would you rule out challenging Governor Perry in a primary?
Same answer, and that is that
Well, you know, you didn't say no.
Well, the answer is I'm not even thinking about if Perry's going to run, not run governor. You're assuming that I would be running for governor.
Well, I'm assuming that the possibility exists.
The possibility exists that I may not run for anything.
The only person in this city who may not be talking about you running for governor is you, apparently, up on this stage. You don't care about that, do you?
No, because what I care about is that these people in this audience and people around the state of Texas know that they have someone who is fighting for their constitutional rights.
Yeah. If I asked you to endorse Governor Perry for re-election right now, you wouldn't take debate, would you?
I don't know if he's running.
Well, if you find out, would you tell me? Because I hear things, but I also think other things. So you're just not going to go there. Okay, well, let us give General Abbott a hand for his good sportsmanship today. Thank you very much, General. Appreciate it.